May I please, Lord?
Yes.
Lordship, item number 21. It was third appeal, Lordship. Can it be continue or serially, Lord?
Hmm?
It will come, can it be after after the cottage? It will hard, Lordship. 21,
21 is the third hearing.
Lordship.
Let the hearing reach you be here. We may think of upgrading the matter.
Lordship, I beg to mention for listing of an eye. Lordship, this eye is pending since 1 year. So
It
can
was
it
last listed. When was it last listed?
last listed on 28th of August,
Okay.
25th of 11th,
21?
25th
20 Monday.
August.
May it please your Lordship, I beg to mention with regard to item number 22,
Yes.
Lordship. Lordship, today it has been filed, Lordship. Kindly take up the matter day after tomorrow.
Okay, Friday. Item number
22, Lordship.
22.
Deeply up.
Miss B. Devi, Learned Counsel for the appellant, submits that an I is being filed today. What's the para? Today and accordingly placed for an adjournment. Para, list this appeal along with the IA on 22nd.
Obliged. May I please, Lordship, I beg to mention for listing of one criminal appeal on Wednesday, Lordship.
Appeal of which year?
This year, Lordship, but it was last listed on 19/6/2024.
What was the order passed? Admitted.
The appeal is admitted for hearing.
Why do you want the matter to be listed now?
Lordship, to know about the to list it for order, Lordship.
Why?
No, I was not.
You
Yeah.
should know why you want the matter to be listed. Then only we can consider your prayer. If you do not know, you get the instructions why you want the matter to be listed. Okay. Yes. Next.
May I please, Lord? Item number 15, Lordship.
15.
I'm sorry. The engaged counsel is out of station, Lord.
15.
15. Engaged counsel is out of
Okay.
station. Let it come
Madam?
Monday, Lordship.
Okay. But it's for orders, isn't it?
But orders, sir.
Why is it for orders?
I'm not aware, Lord.
I
Okay. On a prayer made on behalf of Sri J.C. Gogoi,
Just go good.
Learned Counsel for the appellant, matter is adjourned to be listed on
Monday, Lord.
25th.
Apply. Item 1.
Exactly. But this is new matter, मतलब first time मतलब
Conviction under?
302.
Okay. Right. A.M. Borbhuya. A. Begum. Admit. Call for the records. Is there any informant as a party? No.
No one.
Okay. A state respondent that I take. 6 weeks. Records. Or service of Patana Hayate. IA for what?
मतलब IA for bail, man.
Okay. Notice, 6 weeks. Same. Okay.
after received also.
Yes. I had objection if any likely deliver.
Item 2.
It.
Lordship S. Jahan will appeal, Lord. He is in legs and stuff.
What is this matter? Are you taking leave?
State appeal, Lord.
Taking leave to appeal?
Lordship.
So, Lordship, we have already filed an objection, Your Lordship.
Okay.
And there is a drawback. Appeal filed by the state is devoid of any merit, Your Lordship.
No, that's a different matter.
Yes.
On the aspect of leave.
Lord.
What is your objection?
Objection, Your Lordship. Because we have, para-wise, we have made an objection, Your Lordship.
You were acquitted.
Yes, Your Lordship. Been acquitted.
How many witnesses?
As many as 6, Your Lordship.
As many as?
6 witnesses were examined, Your Lordship, including the IO, Your Lordship.
What was the offense?
Offense is the Lordship, POXO is brought in POXO 4, 376, 366, you lost it. Allegation is that she has been kidnapped, you lost it on the way, when she was on the way to her sister's house, you lost it. From the street, she was forcibly taken.
Victims statement recorded.
Yes, you lost it. And there is a variation, there is a total contradiction of the decision because she has improved her version before the court, you lost. Because before the police is different version, you lost it. Again, coming to the court, you lost it, is the improved version, you lost it. So there is total contradiction, you lost.
Madam,
This is the vital one.
Leave is pending.
that is it.
There is no condemnation.
No.
Yes, file objection to the leave.
Leave. Lordship will see the, my grounds, the main grounds for the acquittal was that she had, there were discrepancy in statements. She had said in FIR that applicant.
FIR was lodged by her only.
FIR was not. And she said that in her FIR, she said applicant had kidnapped her. Whereas in her trial statement, she said 2 persons came and kidnapped her. Then the father had not lodged the FIR, not lodged the missing entry. Instead, they waited for her to return. And there are other grounds, Lordship, I'll just say.
What
Then,
about the medical evidence?
Lordship,
What about the medical evidence?
medical evidence, of course, was not in her favor. That was done after many days. And then it was not, no injuries were found. But the fact remained, her statement before the trial court, before the magistrate and before the police, they were all consistent. She said she had come back from Dhubguri when she was on her way to her house. The applicant came, 2 boys came in a vehicle, picked her up, took her, and then took her to an unknown place, and the applicant had raped her. And thereafter, the applicant had brought her home, dropped her in front of her place. She informed her relatives came and rescued her. But in her, the trial court held that it was age 16 to 18 years. That was the doctor's opinion, 16 to 18 years. But her statement, and even the uncle said that she was dropped in front of her place. Thereafter, she informed and family members went and rescued her. So there are corroborations also. Not a case of acquittal, I may say. And paragraph, there are so many corroborations. Even before her police, she had said the same thing. Nothing to disbelieve her. Age is that. So, in fact, delay in lodging the FIR, there is also a reason because they were searching her.
She had lost the FIR.
She has lodged the FIR.
After how many days she was dropped back?
2-3 days.
And when was the FIR lodged?
FIR lodged.
After 10 days, you lost.
No. From the date of her.
From the date of occurrence, you lost it.
Not from the date of her occurrence. From the date when she was dropped.
Brought back to the house of the parents, you lost.
Yes.
From that 8 days, you lost. From that, you lost.
112, no?
Yes.
112 is the occurrence. And 1412.
2011 is the occurrence, you lost it. 2011 is the occurrence, page number 15. Page 15 of the document.
Yes, 1st of December 2015, FIR was lodged. And 2011, of course, 2011, she was kidnapped. From 2011, she was not there. And when she came back after that, the FIR was lodged.
Mr. Diwan, what is your age?
My lord, may I submit on
What is your age?
My age is, you lost it. I'm major, you lost it.
What is your age? We know you are a major. What is your age?
20, about 20 years, you lost it.
Okay. What do you do?
And she alleged
What do you do?
so lost it. I'm an unemployed, you lost it.
Professional kidnapper.
No, not at all, you lost it. So
What do I
last
do? I do kidnapping.
so last it, the case has been decided on mainly on 3 standpoints, you lost it. And 3 vital standpoints, you lost it. First of all, you lost it. FIR is lost after. From the
Madam, on a serious note, see, presumption is already there, and here it's fortified by an order of acquittal. And the materials which you are showing, we do not know what we are going to decide on the leave, but on the appeal, do you think there are merits?
In fact, the Lordship knows the requirement is that her statement has to be consistent and to the confidence of the court. It should inspire. Here, her statements are consistent and there are corroborations. Medical evidence will take a backseat. 16 to 18 years is the finding of the doctor. She is otherwise a minor.
Now, what is the explanation of the delay after she was brought back to the house?
Yes.
How has
there-
she explained it?
in fact,
Initial, okay, missing report not done, okay. But that will also raise a question. Yes, she is missing for 2-3 days. Why not a missing report? Number one. But still then, you can overcome that.
Huh.
But after her, you said that she was dropped in the uncle's place or her place, wherever. Thereafter, how many days?
No, the Lordship, that I have to check which day she was dropped.
See,
In
in all
front of her
cases,
place.
all cases, delay may not be a fatal factor.
Huh.
But it depends on facts and circumstances.
But
Here
that
is a
will-
case where she herself has lost the FIR, Ejahat after not the parents.
Hmm.
An allegation is very serious, kidnapping and rape, minor.
The Lordship will
Lord-
see during the hearing.
Lordship, I have to give the answer of the query put by your Lordship that he is a kidnapper or not.
No, he's
What
not
happens is that
kidnapper.
you Lordship,
That
Since
was
you are
a
not
lighter tone.
Since you are not answering, so we give you the answer.
Lordship actually because I am Lordship above 20 years, below 25 years, you Lordship. Because that tendency is there, you Lordship. So I develop love affair with the girl, you.
Tendency.
And you use so there's a love affair, you Lordship. And therefore she came, you Lordship.
Tendency seems to be dangerous.
No, Lordship. But I didn't went there. I didn't went there and kidnap her, your Lordship. She came to my house at her own volition, your Lordship. Stayed my house for 4-5 days, your Lordship. After that, your Lordship, parents came to my house, your Lordship. Brought her back, your Lordship. Asking me to come to my house, your Lordship, as the your Lordship, this daughter-in-law, your Lordship.
At counsel for the appellant accordingly submits that he may be allowed to take fresh steps for service of notice upon the respond number 2. Para. Let fresh steps be taken within a period of 2 days through the office of the learned PP, Assam. Full stop. List. After 4 weeks to enable Miss A. Begum, the learned APP Assam, to obtain instructions on the aspect of service of notice upon the respond number 2.
Obliged.
You take it by tomorrow.
Lord,
You can immediately send it.
Again, 6 and 7.
6 and 7. Yes, Mr. Sharma.
My lord, that arising out of the same conviction, my lord, my concern is with the 7. Because 6 was tagged with me because person is there is none to help him, assist him. So if I argue item number 7, my lord, then 6 will also cover.
This is for what? Today, I is for?
IA is for my additional evidence.
Okay. That has been allowed.
No, pending.
You want to argue on the additional evidence application, or which one you want to argue what?
I will, my lord, first argue on additional evidence.
On that application?
Yes, IA.
IA?
Yes.
Yes.
He is for the, my lord, the
I'll put the
informant.
And madam? Are you ready for the? Where is your application? IA 911.
Yes, my lord.
Why do you want to adduce additional evidence?
Because there were certain developments, my lord, whatever, and the person on whom the accused in item number 6.
You have filed this under 391.
Yes,
Yes.
391.
Okay.
But the person in item number 6, Pasanta Naik,
Yes.
it is said in the pursuant story is that, my lord. Of course, the informant has now married another person and fled away from this. His client is very unlucky, my lord. His client fled away with another man, leaving everything. Anyway, so she brought an allegation that her daughter was raped, raped in the sense, my lord, candlestick was inserted, a minor daughter. On that basis, the case was made out. And the allegation was primarily, my lord, first this Basanta Nayak was the person who picked up this girl while she was playing with other children and handed over to accused number 1, that is in item number 7. But on that day, my lord, it is a procedural story, my lord. The incident took place in the afternoon of 6/6/2019. But this man, the Basanta, was in hospital, my lord, because he has some alcoholic syndrome and other things, liver problem. He was in hospital, tea garden hospital. From the morning up, at night he vomited, early night, 5th night. And
You are for Umakanta, isn't it?
I'm from Omagan.
What is your, what evidence do you want to adduce additionally?
There, my lord, the medical, because the prime person,
Vasanta,
Basanta, on whom the allegation of
he
picking up
was,
the,
he was in hospital.
yes, he was not there in the scene.
Hmm.
Because the alleged crime took place, my lord, in the afternoon, and Basanta was from morning, from earlier night of 5th June, he was suffering and he vomited. Then he had to be admitted early in the morning because he's a tea garden worker. And if he was not there in the afternoon. If he was in hospital, that aspect was to be brought because the hospital,
So what kind of evidence do you want to adduce now?
the
The aspect of hospitalization of
yes,
Basanta?
yes,
Why didn't you, what prevented you from adducing the evidence at the defense?
my lord.
What prevented you from adducing this kind of evidence at the
That
trial?
is where sometimes we
No,
also
is 391 a matter of right?
and 391 in a my lord, I brought 2-3 judgments, my lord. It is exactly not a matter of right. But for the ends of justice, my lord, the court should not check his hands. Now, my lord, one thing more. First, your lord should come to paper book. Main paper book, my lord. Why? This is
First read 391.
yes. Here. 391 is as good as, my lord, 311. Of course, that is during trial. And 391,
311 is slightly different.
that is during the trial, not
No,
post trial.
not only of this stage, otherwise
Yes.
also it's slightly different.
Yes. Yes, my lord. 391, appellate court may take further evidence or direct it to be taken. In dealing with the any appeal under this chapter,
Now, first read, if you're making a comparison with 311, read 311 first.
and that is not in the trial court.
Not only of the stage of trial. See what are the
Yes.
embargo or what are the restrictions, if any, under 311.
Yes.
And vis-a-vis 391.
Yes.
First read 311.
Yes.
Power to summon material witnesses or examine person present.
Yes.
Any court.
Any court may at any stage of any inquiry, trial, or other proceeding under this code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall or re-examine any person already examined, and the court shall summon and examine or recall or re-examine any such person if his evidence appears to be essential to the just decision of the case.
See here, this is a power of discretion which can be exercised so moto also.
No more role.
So moto, but just see, suppose you see read 391.
Yes. In dealing with any appeal under this chapter, the appellate court, if it thinks it is the evidence to be necessary, if it thinks,
Shall
record
record
his
its
reasons and
See,
may either take
there's
such evidence itself or direct it to be taken by a magistrate, or when the appellate court is a high court by the court of session or a magistrate.
here there is an obligation casted on the court to even to record reasons.
Yes.
It is not a routine manner.
No.
If
not
I
really.
think fit,
No.
that's not enough. I have to record reasons.
Yes.
Why I'm allowing this?
Yes, that is
Unlike 311.
yes. 311 court
discretion
can for
is
just
a
decision.
vast discretion.
Yes. Further matter, when the additional evidence is taken by court of session or the magistrate, he shall certify such evidence to be to the appellate court, and such court shall thereupon proceed to dispose the appeal.
Now, this version which you are now projecting.
Yes.
That
Na-
the Vasanto, that accused
Yes.
number one, Vasanto was
Yes,
in
yes,
in hospital.
Yes.
This was an existing project.
That's what I am there. That's why I am taking your lordships to my lord, the paper book, the statement of 313 of the Vasanta, where he stated this fact. But the court, your lordship is aware of the Reena Hazika case, which went from this court only, this Supreme Court. 313 statement, though not taken an oath, neither supported by affidavit, is as good as an evidence on the part of the accused. So may I read my that 313? I might have quoted here also, my lord. Just a minute. Three and 13, my lord. In paper. Yes. Page 21, my lord. To 25.
Which question?
My lord.
Which question?
That
Which question number?
Question number, yes, just I.
Question number 12,
Yes,
page 24.
yes.
This is a false accusation against me.
I am innocent. At the time of occurrence, I was admitted at GMCH, Zorar, for high blood pressure. Actually, not high blood pressure, but it's alcoholic syndrome. Because you are transferred from,
How do you know? He says a high blood pressure.
my lord, because you are also going to see.
He doesn't say about
No,
any
I have
other-
annexed that medical certificate. I have annexed this medical certificate. my lord.
Where? Where
In
have you
the
annexed?
IA page number 9. Page number 9, 10. This is the medical officer of the Assam Company Limited. This is to certify that it is dated 4/8/2020. This is to certify that Sri Basanta Nayak, 45, who was suffering from urinary tract infection, fever, was sent to Jorhat Medical College Hospital on 6/6/2019 at about 9 a.m. by Garden ambulance for further investigation and treatment. Because he was admitted earlier, then why the treatment could not be completed there?
This certificate is given in 2023 or what?
Yes,
After how many years? 4 years.
yes, after the no, after
4
the-
years.
after 4 years of the
On basis
institute.
of what?
Then my next page. Jorhat Medical College. This fact was stated in 313. He was in hospital.
No, he has just stated for BP he was in hospital. Now this
Whatever it is, but he was in the hospital. Admitted 6/6/2019. Released on discharge on 13/6/2019. Hospital number so and so. Department register number so and so.
Let us see the original of this discharge certificate.
Thank you, like. Illegal.
So, এইটো 313 ই কোৱা নাই 300 বেলেগ বসন্ত কৈছে এইটো উমাকান্ত নহয় উমাকান্ত he wants to take advantage of this no who কৰিলে হা এইকেইখনো ডাউটফুল হৈ গ'ল তো এইখন কেতিয়া আনিছে বাইশৰ কথাও নহয়। অফাৰ ইনসিডেন্ট যে পঠোৱা বস্তুটো 6/6/2019 বস্তুটো কি বেচিছত দিছে? এটা পঠালে এটা ৰেকৰ্ডো নাথাকে নহয়।
No, my lord.
So what is the answer to question number 14 at page 24?
Sorry,
Yes.
Lord. There was the order of 15/11/2023, Lord. The ILP had a final hit.
Is it?
Lord, page 15/11.
Subsequently, I think it was separated.
2020.
Subsequently, I think it is separated.
15/11, Lord.
In the IA itself?
Lord, it's 15/11/2000.
Okay. IA has been filed through a period.
Subsequently,
Shall be considered stage of final hearing.
Lord, it's the
we'll
paper
hear
is
it.
also ready, Lord. Maybe hard it,
Paper book is there.
everything,
everything is ready.
Paragraph, question number 14. The main person who says that he had he had a defense of LIB.
Yes.
But he did not, he said that I am not going to adduce any evidence.
Lord.
He could have very well adduced evidence.
My lord, before that, your CFP.
Then why has it come for orders today?
I think this was, this I was there, that's why, my lord.
No, the order has been passed.
my order.
Okay. We'll have the appeal for hearing.
Paper book.
Okay.
Can
Third free.
can I speak, my lord, that it early, because the man is 60, about 67, 68 years old. Old man.
67, 68 years, not old, young.
For your lordship. Of course, your lordship has not attained that age.
You say 67 is old, 67
No.
is young.
No, for your lordship, your lordship will be like this only, with the same face up to 80, I think. There is no change at all since I saw you. Huh? What, 69? I think.
He is not 60.
69 running. So can I pray for
Appeal of which year?
2023, man?
24.
Yes.
One is 24, yours is 23.
Yes.
What about the amicus in the other one?
Is there? Oh, there is none. No. So these just may cover. My argument will cover that.
But would like to have the assistance of the amicus or
Yes.
legal aid counsel, whoever. Okay. We'll have it when? In the first week of January? Is it okay?
Can you be a bit early, man? Because the man is suffering. That's why I'm
Suffering what?
What?
Suffering from?
Yeah, he has a lost his mother in his old man of 60 years, 69.
All matters are important.
Well, can it
24,
be,
23 matter, giving a date into January 2025 is good enough.
well, can I
And
pray?
had it been a case of some gross illegality, matter would have been different. We don't find anything. And say,
No, there is one.
acquisition is very serious.
There is one. There is illegality in not considering that
Acquisition is
step.
very serious, very serious. Whatever you have narrated, without that, of course, will not cause any prejudice to your
Yes.
decision-making process.
Yes.
But still, then
Well,
cannot be wholly ignored.
Can it be in December, Maro, somewhere?
We'll have it in first week of January. Okay.
Okay, let me
heard
mind in there, Maro.
Sri R.P. Sharma, Learned Senior Counsel for the appellant in
almost
criminal appeal 92 of 92. 92.
Yes.
92 of 1923, assisted by Miss Yodeka Edeka. Assisted by Miss Edeka. Also heard Miss who will appear? Bhuya or also heard Miss Begum Learned APP Assam, as well as you for
Respondent,
as well as Sri L.R. Mazumdar for the respondent number 2. Informant or victim?
Yes.
Victim or informant?
Informant.
Informant. Para?
Well, can it be on 17 December, Maro? Or 10 December.
17 December will not be possible. Last
Yeah.
week before the vacation. Have it in the first week of January. We'll give you a date. Um, do Para. Do the connected IAS criminal 911 of 2023 has been filed seeking
First week
leave
of January
to
is
deduce additional evidence under section 391 of the CRPC, this court had passed an order on 15/11/2023 that the prayer would be considered at the stage of final hearing of the connected appeal. And in fact, the matter was and in fact, the matter has been, and in fact, the matter was directed to be listed for hearing. Full stop. It, however, appears that subsequently the connected appeal, criminal appeal 65 of 2024 has been filed by the co-accused.
from the jail. jail.
Co-accused from the jail, who is not, who is represented by a legal aid counsel. Legal aid counsel.
Yes.
Para, considering the above and also the fact that paper book has been prepared, the appeals may be listed for hearing
On 7th of January.
on
7th, my lord.
7th January.
Yes.
7th January.
Kindly,
Kindly inform the council. Of
his
the other
name
case.
his name will be shown, my lord.
Whose?
SK sir.
Name is shown. It has been shown.
Yes, sir, Mahathir. Both matter will come together, my lord. Both the matter will come
Both
together.
appeal.
I'm like,
Right, please.
Mr. Das, what is this?
Service upon respondent number 2A has been completed, and the record has also come. Lodgement directly registry to prepare paper.
Poxo matter. Poxo.
No matter that someone is to be appointed.
Yes, we'll appoint somebody. Okay. Heard Sri J. Das, Learned Counsel. You're amicus or legal aid?
Legally.
Learned Legal Aid Counsel, who by referring to the office note dated 18/11/2024 has submitted the service of notice upon the respond number 2 is complete. Para, also heard Ms. B. Bhuya, Learned APP Assam. Para, this appeal was admitted on 18/9/2024, whereafter the records and the LCR have been received. Full stop. Para, let the paper book be prepared. Para, since the respond number 2 has not engaged any counsel, let at least counsel. Madam Borpujari, you're a legal aid counsel. Okay. Ms. D. Borpujari, led Bully Kolonaki. We appoint Ms. D. Borpujari, Learned Legal Aid Counsel, to appear on behalf of the respond number 2. Para, let her name be reflected in the cause list. Para, after preparation of the paper book, the matter may be listed for The copies of the same may be furnished to the learned counsel and the matter may be listed for hearing.
Obliged.
Item 9.
Then appeal, my lord. Record was called for, and my lord, appeal yet to admit. Take up the order, my lord.
Appeal not admitted.
Just my lord, perhaps not yet admitted. My lord, let the appeal may admitted, my lord, and so far, my lord, the service is concerned, my lord. It was issued, but it was not reflected whether it is served or not.
Uh, Heard your K. Barua.
Okay, bro.
Heard Sri K. Barua, learned counsel for the appellant. Also heard Miss B. Bhuya, learned APP Assam. Para. Do records have been called for in this appeal? It appears that there is no formal order of admission. Para. Let the appeal be admitted for hearing. Has the records come?
Lordship, LCR,
As
LCR 6 files.
Para. Office note dated 28/8/2024 depicts that the records have been received. Para. Let the paper book be prepared and upon furnishing copies of the same to the learned counsel for the parties, the appeal be listed for hearing.
This IA,
I will be kept alive.
then we file our
The objection hall has been filed.
basis for it and
Okay, okay.
Is not based on the date of hearing.
Okay.
for the date of hearing.
It kept pending.
Um,
Obliged.
Sri Barua, the learned counsel for the appellant, submits that that instead of pressing the IA at this stage, he would the appeal itself may be heard.
Then we need to file our.
The position should be clear. Tomorrow we do not know who takes
Yes,
up.
file.
Okay, next. Item 10.
May I please, Doctor? LCR has received the paper book is not ready.
LCR received.
Sure.
Heard Ms. D. Borpujari, learned amicus curiae, as well as Ms. B. Bhuya, learned APP Assam. Para. This appeal was admitted by the order dated 4/10/2024. And the records were called for. Full stop. Office note dated 14/11/2024 reflects that the records have been received. Para. Let the paper book be prepared and upon preparation of the same, copies be furnished to the learned counsel for the parties and the matter be listed for hearing.
11. May please.
Yes,
Yes, Lordship, the objection already filed by the comment at Lordship and the IA is pending, Lordship.
I for bail.
Lord.
Okay,
And
you are
the-
for informant.
There are two amicus for that, but and one of them is the art center. S Sarma is S. Also entered.
Okay,
On 8/4/24, the site was radically furnished copy. For
the informant has engaged private counsel.
Yes,
Then we can we can take your assistance, but we'll hear the engaged counsel. Have you filed objection? You'd like to file objection?
Uh.
Who is your senior? Huh? S. Sharma, Sumitra Sharma. Okay, then we'll fix another date. But you, instead of fixing a date, we direct, will you like to file a objection? I think you like to file objection. Private counsel obviously will file objection. Okay, let them file objection. Did you file objection, Mr. Dhar?
My lord, copy memo of the copy has got
Not
its
that.
8/4/2024 order.
Will provide.
On the
Okay.
and
Ah.
lordship,
My one
8/4/2024.
submission, Lordship, at the appellate is 74 years. And on the basis of PRC evidence, only one person, Lordship, and from the parent and close the chapter. Otherwise, there is no any.
Okay,
74
let
years.
them file objection, okay?
Date may be given.
Okay. Do, what is your name?
F.
Part 3 of learned counsel for the appellant, applicant appellant, as well as Miss A. Begum, learned APP Assam, full stop. Do Sri A. Dhar, learned amicus curiae was appointed to appear on behalf of the respondent number 2 informant, comma. What is your name? A. Mandal. Sri J. A. Mandal, learned counsel has informed that his senior, has informed that Miss S. Sharma
Yes.
has entered appearance for the respondent number 2. Para. Let copies of the I as well as memo of appeal be furnished to the learned counsel who has entered appearance. Full stop. The learned counsel for the respondent number 2 prays for and is granted 3 weeks time to file objection to DI.
Lordship, and what submission, Lordship, and date, Lordship, authorized.
List on
Before winter vacation, and date.
it will be difficult.
I only for I.
I also difficult. 3 weeks will touch the vacation almost. Last week of the vacation, there will be hardly any chance. We'll have a date on 18th. We'll try 18 December.
Lord.
18
Public.
December. File
Public.
your objection before that. And
Public.
give copies today.
Now it has provide. Publish, public.
Item 12.
May be lordship. But here, my lord, the IA, my lord, objections have not been filed. And
I
as-
for suspension and
Yes.
bail. You like to file objection, madam?
Lordship.
And as
Okay.
per Office Notice 411, my lord, the service is not complete.
Is there two?
Please note.
We may not insist upon the service. Okay.
Yeah.
302. Foxo is not there.
Foxo is not.
No, that is true.
You will not say anything about that. On the prayer of Miss A. Begum, heard, heard
N.
Sri N.
Mahajan.
Mahajan, learned counsel for the applicant, appellant, para. On the prayer of Miss A. Begum, learned APP Assam, matter is adjourned by 3 weeks to enable her to file objection.
4.
4 weeks. Oh, 4 weeks. Okay.
Apply.
List in the first week of January 2025. You ensure filing of it. We are giving you sufficient time.
Sir.
Item 13.
Lordship, as per office note dated, office note, Lordship, the service on respondent number 678 is complete. And in respect of, Lordship, service, 1, 2, 3, 4, and 5, Lordship.
Insufficient address.
Insufficient address. But their address is reflected in page 12, Lordship.
Now, this is a conviction under what?
No, Lordship, this is for against acquittal, Lordship.
Against acquittal?
Lord.
Okay. You are the informant.
Lordship, I am the informant.
But you have to serve them.
I am the Lordship wife of victim.
Wife of the victim.
Lord.
Victim means he had passed away.
Lordship. 302, Lordship.
So what do you suggest? 1, 2, 3, 4, and 5?
I have taken instruction. for
Take instructions.
About their address. But their address is reflected in page 12. But in charge. With
Pardon?
Jasmine Lord.
You are Ayub
Ayub
Chaudhary.
Chaudhary, sir.
Heard Sri Ayub Chaudhary, learned counsel for the appellant, as well as Miss A. Begum, learned APP Assam, para. In view of the office note dated 13/11/2024, Sri Chaudhary, the learned counsel prays for and is granted 3 weeks time to obtain instructions on the aspect of the complete address of
1 to
the
5.
respondent numbers 1, 2, 3, 4, and 5.
Deeply over.
With my lord, in respect of action number 9, my lord, my lord, lordship dispose of the IF because there is the appellant number 1 is, my lord, aged about 82 years.
We have
I-
not disposed of.
Not disposed. So, my lord, I will praise the IO after, my lord, the preparation of the paper book.
On that, we have to clarify.
But-
Where is madam?
Is in Lake.
You could
I will-
could have clarified that moment.
But-
You said that you will press it at the time of appeal.
Lordship, my lord,
Now said that you will press it after
I'm-
preparation of paper book. There are different, these are different.
I'm sorry.
কি লিখিছিল? বি ভূঁইয়া। No, the records have been called for. Formal order of admission. No? Formal order of admission. Admission of the appeal. No. Press copies nahi. Press nahi. And copies of this. Be furnished. No, Sri Barua, right to Sri Barua prays for and is granted liberty to press the IA after preparation of the paper book.
Like,
Item 14.
My lord, here, my lord, LCR is received, my lord, and paper book is not prepared. And
LCR has come.
Yes, and further, my lord, office note dated 13/11, say, my lord, no unserved notice nor AT has been.
302, not POXO.
30.
Let it be like this.
Yes.
Okay. Office note dated 23/9/2024 reflects that records have been received. Para, let the paper book be prepared. Whereafter, the matter may be listed for orders to fix the date of hearing.
Obliged.
Item 16. Yes.
May I please, lordship? The IA is for condemnation of 18-day delay. To file in the connected.
Come for the first time.
Come for the first.
Will issue notice of this. Heard Sri A. N. Mahajan, learned counsel for the applicant who by means of this application filed under Section 5 of the Limitation Act 1963 has prayed for condonation of delay of 18 days in preferring the appeal. Para, let notice be issued. Ms. A. Begum, learned APP Assam, accepts notice on behalf of the respondent number 1 state. Para, let steps be taken for service of notice upon the respondent number 2 through the office. It's a POXO.
POXO.
Through the office of the public prosecutor Assam. Steps within 2 days. List after 6 weeks.
Obliged.
Item 17.
May I please, your lordship? Matrimonial appeal, lordship, delay of 11 days, lord. Delay was caused by in providing me the copy of the order.
Heard Sri M. Bhagavati, learned counsel for the applicant, who by means of this application filed under Section 5 of the Limitation Act 1963 has prayed for condonation of delay of 11 days in preferring the connected appeal. Full stop. Let notice be issued. That steps be taken for service of notice upon the sole respondent by registered post with AD. Steps within 2 days. List after 6 weeks for service report.
Item 23, something is.
Withdraw.
Lordship,
Withdraw.
every one part.
IA was for what?
For condonation.
Condonation of the
But the appeal is yet to be registered. Where is the question of conversion? Converting an appeal to a revision that we would have allowed. Appeal is yet to be registered. You withdraw this. We'll direct the registry to furnish back the paper, the certified copy. Okay. You can file Section 14, or you can get the benefit of Section 14 also. We should not advise you. You are pursuing a remedy bona fide in a forum without jurisdiction. Appeal doesn't lie.
If so advised, he can file.
Obviously. No, he is withdrawing with the
And
liberty.
because Lordship, he is on the pretext that certified copy from her type will produce, saying this Lordship in my execution, they are not paying area of 2 lakhs for.
No, that is up to that court. If the court
Lordship, they
if
have
the
already
court
filed
is,
the
inclined
execution.
to stay a proceeding in spite of there is no orders, then you know what to do.
They have already filed Lordship execution suit.
Then
Execution itself, they are saying that we will produce order from the High Court.
we will not do. Let the you know what to do. Let them produce. Why should we clarify that there is no order? We clarify that there is an order, but there is no question of clarifying that there is no order.
Lordship, may I say one thing, Lordship? Lordship, the period Lordship from filing of this appeal, Lordship, and till Lordship Friday, Lordship. This period.
That is what we are saying. 14. You take advantage of 14. You haven't read 14 of Limitation Act. Have you read? Not read. Not read. You read 14. What is 14? Okay, we'll not waste time in making you read 14. Let us pass orders. We have got many other things to do. Okay. That's very concerned. Family Court Act. The instant IA has been filed for condonation of delay has been filed under Section 5 of the Limitation Act 1963 for condonation of delay. Full stop. The same has been filed in connection with a challenge made to a judgment dated so-and-so, passed by so-and-so, which has been made by way of an appeal. Full stop. After issuance of notice in the IA, the opposite party has entered appearance. Full stop. We have heard Sri A.M.S. Mazumdar, learned counsel for the applicant, as well as Ms. R. Chaudhary, learned counsel for the opposite party. Para. Ms. Chaudhary, the learned counsel, by referring to Section 19 of the Family Courts Act 1984, more particularly Section 19 (2), has submitted that no appeal lies from the order which has been passed under Chapter 9 of the CRPC. Full stop. The instant challenge is against an order passed under the aforesaid provision of Chapter 9 of CRPC. Full stop para. In view of the above, the appeal is not maintainable. Full stop para. At this stage, comma, Sri Mazumdar, the learned counsel for the applicant, submits that he may be allowed to withdraw the appeal and file it and make the challenge in the appropriate manner prescribed by law. Full stop. He has also submitted that since the appeal itself was barred by time for which the IA has been filed, comma, certain some observations may be made on that aspect. Para. On after hearing, comma, we the appeal is allowed to be withdrawn with liberty to make the challenge in the manner prescribed. Full stop. It is needless to state that the applicant may take recourse to Section 14 of the Limitation Act 1963, apart from the grounds taken in the present IA for condonation of delay, which would be liable for consideration. We also direct the registry to hand over back the certified copy of the order of the order dated so and so, of the learned so and so, which was annexed to the appeal.
I have 14 part.
Obviously.
Lord.
No, not 14 and so entire thing. We have not
Yes.
passed anything on merits.
Lord.
He is under a burden to explain 110 days.
There are some false averments where
We make it clear
we have
that-
already filed our objection.
that since objections were filed in the IA, no the consideration of the of any application that may be filed for condonation of delay would be decided strictly in accordance with law
Yep,
and without being influenced by any observation made by us.
I'm deeply up.
Okay.
IA appeal sub. Withdraw. Is it yours, no? Mr. Das, you are for which matter? That reference.
Yes.
We have it.
But,
there.
uh,
We have.
we were in the midst of a hearing of Mr. Sharma.
Yes, well, I think item 21 is there.
Yes, we had heard for at some length. So you'd like to finish that after, how long will your matter take?
Little long.
Really?
It's about 20 witnesses are there.
May not be possible, this bench is slightly uncertain. But that's reference, we
Yes.
don't want to delay also. But today, it may not be possible.
So any other date convenient to the court.
Can we have next Tuesday, try on next Tuesday, Nikki? Try on next Tuesday, can you go bench already to have it? Apne asame next week?
Keep up, right?
Oh, why it was? Here next Tuesday. No. No, let it be not next Tuesday. Let it be after 2 weeks. You are here otherwise? 2 weeks?
Yes.
After 2 weeks. Mr. Chakraborty for whom?
And for the appellant matter, file an appeal also. Sir. 19
19.
for the appeal.
Okay. And Madam Bhuya appears for the.
Actually, we have done.
Okay. On a joint request made by the Senate Council for the parties. Matter is adjourned by 2 weeks. Should we fix a date? On 2nd of December or 3rd of December? 3rd December, Tuesday.
If you can avoid third mallet, I'll be obliged.
Oh, on 2nd?
Second, Melon, I have some difficulty, Melon.
Let it be on the 4th or
4th. 4th
Yeah.
December. 4th December. Okay. Mr. Mazumdar, there is a part-heard matter. Okay, after that, what is your matter? 302? You are an amicus? Okay, we'd like to have your matter after this matter. This will not take much time, okay? Keep a watch over the matter.
All right.
Other councils, you have matters? Mr. Das, any matters? Atria, any matter? No. Other matters may not be possible. We'll take up Mr. Mazumdar's matter after this session. Okay. How to now also better.
The last day lordship.
Just a minute. PW to Pankaj is related to the deceased
No, friend.
friend. Pankaj Devnath is friend of Abhimanyu.
Yes.
Pankaj was also traveling with him in the same vehicle.
Yes, sir.
He jumped out of the vehicle.
He jumped out of the vehicle.
That is his version.
That is his.
Okay, we were in PW 13.
Yes. Yep.
Are you?
IO.
Okay.
Page 36.
30?
Three. Met. And on 21/7/2014, while I posted as PSI at Jagi Road PS, on that day, while I was performing patrolling duty at Jagi Road area, Ajit Devnath along with few others informed me that one of his vehicles was taken by few persons on hire, and the vehicle and the driver was missing. His nephew Pankaj Devnath was assaulted, who took shelter at village Bazari. On getting this information, same was entered in GDNT book by Jagiro's PS GDNT number 610 dated 21/7/2014. And after informing the matter to the then OC Jagiro PS, I went to Bazari village with the informant to investigate the matter. Accordingly, at about 1 in the midnight, I arrived at the residence of Rajan Bora at Nahotia village and recovered Pankaj Devnath with some injuries. He and Rajan Devnath were interrogated. This Rajan Devnath were never been made any witness in the process, were interrogated. With Pankaj Devnath, I returned to Jagirot PS and provided treatment to Pankaj Devnath. At about 2 a.m. on that night, by Pankaj Devnath, I along with OC came to the place on Dhokatgaon.
Who is Rajan Devnath?
Rajan Devnath, he was not.
Now, what is the meaning of this? Accordingly, at about 1 in the midnight, second paragraph.
Yes, sir. Yes.
Accordingly, at 1 in the midnight, I arrived at the residence of Rajan Bora.
No, Rajan.
No, we do not know. That is what PW1 was Decca. He says, accordingly, at 1 in the midnight, I arrived in the residence of Rajan Bora at No Bahatia village and recovered Pankaj Devnath. Who is with some injuries? Who is Pankaj Devnath? He is the informant.
Then again, he again.
Pankaj Devnath. He and Rajan Devnath were interrogated. I think this is a wrong recording.
That Rajendra, yes.
It should not be Devnath. I think either Bora or Deka, not Devnath. Because, see, the villagers had informed him after getting the phone call from the house of Rajan Bora or Deka. And that the informant was in his house. So they take the police personnel goes there, interrogates both Devnath as well as Rajan. But I think it's not mixed up. Then again, with Pankaj Devnath, I returned to Jagi Road and provided treatment to Pankaj. Okay.
At about 2 a.m. on the night, that Rajendra become hostile lot. That pick up blue part. Rajendra said that nobody came to her house, his house. At about 2 a.m. on that night, Pankaj Devnath, I along with OC came to the place at Bhakartam Mayang Road where Pankaj Devnath was thrown away. I have drawn a sketch map of the state place. Exhibit 7 is a sketch map of the state place. Exhibit 7.1 is my signature. On that day, at about 9 a.m., OC Jagirat PS got an information over phone from Ganesh Vishwas that one dead body was lying in Nakera Habi area. On getting this information, I, along with OC and other police personnel, went to that place and found that by that time, Mayang police personnel arrived there and recovered the dead body. Dead body was identified as of Abhimanyu Vishwas, driver of an auto vehicle by his relative. I have drawn a sketch map of the state place. Exhibit 8 is the sketch map of the state place. Exhibit 8.1 is my signature. I have recorded statement of Kasem Ali, a nearby resident. The place where the dead body was recovered has fallen under Mayank Brazilian dead body for PM examination. Inquest on dead body was also done by Mayank PS. No inquest reports were never been exhibited. While we are at that place, I received the secret information that Mainul Haq, Mainul Hussain, Saddam Hussain, Saidur Rahman of Buraburi area were involved in the crime. During return journey, we searched the houses of the above 3 persons, but did not find them in their houses. Subsequently, basing on some information on that day at about 10 p.m., we could apprehend Moinul Haq from his residence. During interrogation by police, Moinul confessed that he, along with Shahjahan Ali, Dimapuria, and Saddam Hussain, took a auto vehicle on hire from Jaki Road for going to Akashinga under Daboka PS. While going, the driver picked up Pankaj Devnath in the vehicle. While going, they also picked up Saidur, Islam, and Ibrahim in the state vehicle. While returning from Makasinga, they came to Poha under Mayank PS, and during journey, after consuming beer, kept the bottle in the vehicle. It is also stated by that driver that the driver Pankaj and Dimapuria is absent lordship, was sitting in the front side. During going Dimapuria is a juvenile. Or Saddam, yes. During going accused, Saddam hit a beer bottle. On the head of the driver. On going senseless, Shahjahan Elias Dimapuria, Shahjahan Elias Dimapuria took control of the steering wheel and seeing all this, Pankaj get down from the vehicle by opening the door. Saddam and Moinul chased Pankaj. On pretending death by Pankaj, they assaulted Pankaj on his chest. Presuming him dead, Moinul and Saddam boarded the vehicle. By that time, Ibrahim and Saidur get down from the vehicle. Subsequently, Saddam, Shahjahan, and Moinul took the vehicle with the dead body of driver Nekerighat and towed away the dead body. The vehicle stuck there. To get the vehicle free, they went to the house of the Kasem Ali and collected one spade. And clearing the road, they took away the vehicle from the place. By taking the vehicle from, they went to the vehicle and handed over the vehicle to Baharul Islam and Ruful Amin. On knowing this from Moinul, on the midnight hours, I, along with PS personnel, went to Kasaripara under Lahorigat PS with Moinul and searched the residence of Ruful Amin and apprehended Ruful Amin. I recovered the mobile handset of the driver Abhimanyu from Ruful Amin. I have seized the state mobile Exhibit 4 is the and seizure list is Exhibit 4. Signature. On stating by Ruful Amin that he has been given the alto vehicle to his nephew Baharul Islam of the same village, we went to the house of Baharul Islam, and on apprehending him, he handed over the key of the vehicle to me and also stated the vehicle was kept hidden near Mahamora LP store. On being stoned, we went to the place and recovered the vehicle without number plate and seized the same. Exhibit 3 is the seizure list. Exhibit 4 is my signature. We take us Bahul, Ruful Amin, and Moinul. We return to Zakirul. First, here, I was stated that Ruful Amin was arrested first and then Baharul. But witnesses state that Baharul was arrested first. Ruful Amin in the earlier PW with Gauvura state, he was arrested later on. Some later on. On 27/2014 at around 7 a.m., the then OC Zagirod PS has received one written FIR from Pankaj Devnath and registered
Halwating.
PS. Halwating PS case number 2000. PS case number 233/2014 under section 120B 406 420 302 201 326 307 379 IPC and entrusted me to make further investigation of the case. After registration of the case, I have visited the taxi stand of Zagirod and drawn a sketch map. Exhibit 9 is a sketch map. Exhibit 9(1) is my signature. During investigation, I have recorded statement of witness. I have also collected SCD from Mayang PM report. I have arrested accused person, namely Moinul Haq, Elias Hussein, Ruful Amin, Baharul Islam. On the next day, Saddam Hussein was produced at Zagirod PS by his father. On completion of
Just a minute. Zakirod PS usi FIR loy pela Halwating kene kohil Zakirod hole signature. 34, page 34. Last paragraph. Itu Halwating police ini. I think this should have been Zakirod PS.
Zagirod PS, yes, sir.
At page 34, last paragraph, second line. Because it was registered with the OC Zakirod PS. It could not have been Halwating. It should have been Zakirod.
Okay, here one when PW4 says that Baharul Islam was arrested first, Ruful Amin was arrested later on. But here IO says that Ruful Amin was arrested first, then Baharul Islam first. PW4 says that in part arrest part first.
PW4 is a Caesar witness.
Yes.
Abdul Jalil.
Yes, he says that
Gauvura.
yes, Gauvura says that he led the police and he saw that and arrest Ruful Amin first. He first apprehended Baharul Islam, then Ruful Amin. But IO says first Ruful Amin, then Baharul.
How will you make a material change in your stand of defense?
No, Lordship, here I'm just saying
No, inconsistency, okay, but all inconsistencies will not be material. It has to materially affect your case.
Yes, my materially affect my case is the only point is here, Lordship. Here, the prosecution could not give the circumstantial sequence, Lordship, because 174 that inquest is not done here in this case. Not exhibited. There is a specific judgment by this court, Lordship, by Honorable Court, by this court, Lordship, I am the judgment, Lordship. When inquest report was not exhibited, then that link is failed. 174 that proceedings is not being done. The prosecution then the burden of 106 is also not based on us. giving proper explanation because the inquest was not being placed, Lord. Lordship can go to this judgment, Lordship.
Inquest is a part of the investigation.
Yes, Lordship. But here, Lordship,
Will
here,
it be
Lordship,
fatal in all cases?
yes, materially fatal, Lordship, for the prosecution. If
In
inquest
all
was,
cases?
in all cases, Lordship, can go to this judgment.
Can it be a universal principle?
Huh, Lordship?
Can it be an universal principle? The inquest not done or not exhibited?
Yes, Lordship, which is as per this judgment, Lordship. Lordship can, that is right. It is from the 2008 also, para number 33 also, Lord, can go to it. In the case of terror, the division bench also held that the documents, including the FIR, search sheet, postmortem examination report, seizure list, inquest report, etc., which are relevant and necessary for the prosecution, are to be exhibited and considered. The above case was in relation to the accused person having been found guilty under section 302-384-21 and read with section 2 and 2. In terms of rule 9 of here, Lordship, in this is a reference, Lordship. In this case also, Kalyan Burma, it is 2023 matter, Lordship. He was being acquitted only on that ground. That
Show us.
para number 33, Lordship.
Yes. In the case of state of Mizoram.
And then 22 sentence, conviction sentence awarded up to accused person in terms of rule 9 of the rules of regulation of the procedure officers appointed Mr. in the Lusasil Hills. Amicus curiae for the accused person had taken a stand that FIR, search sheet, postmortem examination, even inquest had not been exhibited and considered when it was in the above context that the division bench of this court had directed that all documents, including FIR, search sheet, included, which are relevant and necessary, are to be exhibited and considered. In the present case, this case is being examined. In the present case, no medical documents, including the inquest report and referral letter, have been exhibited. Unfortunately, the trial court had also not been apprised of the discrepancies in the date and time of death of the disease. Here, same Lordship, date of death and time is not reflected anywhere, Lord. Here in postmortem report, date and time is not being, time is not there, Lord. In the PM report, I will go through it. So this judgment covers in my case. Ultimately, death of the accused compel the fact.
No, you have said that it is an universal principle. The inquest report is not there. No prosecution will succeed. Where is it? Where is the case?
That I am going, Lord.
It cannot be in all cases. Yes, inquest is required to be exhibited, proved, but if not done, will it be fatal in all cases?
Lordship, here, Lordship, how will I, if inquest report is not exhibited, Lordship, then the scope of cross examination is not there from the defense side, Lordship.
No, they have to see if they build up their case based on an unexhibited document, you have a case.
Lord.
If it is not exhibited, there is no foundation.
Lordship,
on the inquest.
here my case is that Lordship, it is based on the circumstantial evidence. That is circumstantial evidence. The prosecution has to give a chain of the events, Lord. So when
See, here it's slightly different. This informant, he was in the vehicle.
Lord.
He saw the assault being made first with a bottle.
Lord.
Then he himself had he jumped out of the vehicle.
Yes.
He was also attacked by two persons.
Lordship.
And his position is of an injured witness
Lord.
who might not have seen the actual death being caused, but he has seen the assault.
Lord.
We have to examine from that point of view.
Yes, Lordship. That part of in that part, Lordship can go to the PM report. PM report is not supporting the witness, PW witness, Lord. PM report is not supporting the PM, the case of the PM, the case of the PW.
No, PM says strangulation.
Strangulation.
Lordship.
Then Lordship.
Where is the PM? Again, let us see the PM.
PM is 176, Lordship. This is name is Abhimanyu Biswas. Day, time is not nowhere. Time is given, Lordship. dispatch 21/7 as per inquest report. As per inquest report, by whom it is identified by UPC QP data, observed that all the organs were no disease injuries found, right healthy. So that is external appearance, rigor mortis, bones position and character nil, cruise position, size, nature nil, mark, ligature and neck dissection, etc. It reverse ligature mark is seen around the neck is continuous. Scalp healthy, membrane healthy, brain and spinal cord healthy, thorax healthy, all are healthy, lordship. Abdomen healthy. Then small intestine and contains semi-digested food materials present. Facial matter seen in rectum healthy, but others than liver, spleen, kidneys, bladder, all are healthy. Then most importantly, lordship, muscle, bones and joints. Injury nil. Here in the postmortem says injury is nil. This is an deformity, lordship. After he says the PW2 jump out of the vehicle, and he says that he went to the house of the Rajan Deka. He says one of them. That Rajan Deka says no, he has not. Nobody has come to his house. That part is being. That part he is not supporting the PW2 also. And he, during the whole thing, the prosecution story, the PW2 is the one thing consistent that the victim was hit by a bottle. That part is consistent, lot, which has not been supported by PA. And when
Yes. Okay. The physical was the data. That's why I data. I can do it. Yeah.
moreover, lot, one more minor thing, lot.
Normally we translate for the reported district for the whole.
Who other accused or acquitted?
One 25. Yeah. Yes.
I was in the post-mortem report. Lord. Here I'm here this in this case, Lord, in this case, Lord, the prosecution did not produce any medical document of the victim, Lord. Here, no inquest report and no referral letter. In three grounds, Lord, this judgment covers this Kalyan Pawan versus State of Assam covers. The para 13 last part, Lord. In the present case, no medical documents, including the inquest report and referral letter, have been exhibited. Here also, no medical documents and no inquest report have been exhibited, Lord. So and here, Lordship, if we believe the case of the PW2, Lordship, and here he has stated that he has he went to the house of a Rajan Deka denied Lordship, he became hostile. And again, Lordship, if we go to the last part of the IO statement, it's not been completed, Lordship. And page number 35, Lordship. I have submitted search sheet against accused Shahjahan Ali, Dimapuria, Moinul Haq, Shahjahan, Saddam Hussein, Ibrahim Ali, Saidur Islam. Then Ibrahim Ali is being acquitted, Lordship. Ibrahim Ali and Saidur Islam is being acquitted, Lordship. And they were also accompanying the vehicle, Lordship. Under section 120B, 406, then Lordship here, as because here, Lordship, in brief, Lordship, the case of the prosecution is that on the fateful day, Moinul, the Abhimanyu was the driver, and he accompanied the Pankaj Devna. And after that, there is Lordship Moinul and two others, Moinul, Saddam, and Dimapuria. 3 persons was there. And in the from the roadside, they took Ibrahim Ali and Saidur Islam. That Ibrahim Ali and Saidur Islam was being acquitted by the trial court, Lord. And they were also accompanying the vehicle, Lord. And here, Lord, if Ibrahim Ali and Saidur Islam, there is a specific allegation by the PW2 that Ibrahim Ali and Saidur Islam also assaulted them. But there is no explanation by the trial court that why they are being acquitted, Lord. That Ibrahim Ali and Saidur Islam, who accompanied along with Moinul on that fateful day, Lord. So law parity also applies, Lord. There is a judgment also that law parity applies. Yes, Lord.
Parity.
Parity. I'm
with regard to the sentence. Parity cannot be a regard
Parity,
to the
yes,
evidence
no,
available.
No, Lordship. When the other Lordship, I have the specific.
Criminal case, it depends on what matters are against you.
No,
There might be
Lordship.
number of persons involved.
No, Lordship.
But if they are held to be guilty and the different sentences given, then the question of parity may come.
No, Lordship, there is this is a 2023 judgment, Lord. Para 15, Lord. Para 15. When there is similar or identical evidence of eyewitnesses against two accused, by ascribing them the same or similar role, the court cannot convict one accused and acquit the other. In such a case, the case of both the accused will be governed by the principle of parity.
That is the evidence.
Yes, yes. Evidence.
Here it depends. Let us see
Yes,
what
Lord,
is the
that will be
evidence against
appreciated.
Moinul.
Yes, Lord.
We are examining Moinul's case.
Yes, Lord. In Moinul's case, Lordship, PW2 has also.
Which paragraph you had referred here? In
Para 15.
15, Javed Chaukat.
Yes. Against Ibrahim Ali and Saidur Islam, the PW2 has stated that they also attacked him, but they were being arrested. They were being acquitted.
Who stated PW?
Two. Pankaj Devna. In his statement, Lord. Now I came to the next part, Lordship. Baharul. Dimapur was shown absconder. Shahjahan Ali, Dimapur was shown absconder, as I could not find him during investigation. Exhibit 10 is a search sheet. Exhibit 10(1) is my signature. I searched Shahjahan on 2-3 occasions, but found him absconding during investigation. During investigation, I have recorded statement of Rajan Dek. In this statement, Rajan Dek stated, on the fateful night at 11:30 p.m., somebody knocked my door and called uncle, uncle. Then I opened the door. After that, he asked me a glass of water, and I gave him a glass of water. After drinking water, he told me that he was traveling in a Alto car with his friends towards Boha side. The car was driven by his friend, and somebody struck the head of his friend with a bottle. Then he got frightened and came out of the car. Exhibit 11 is the statement of witness Rajan Deka. Exhibit 11(1) is the relevant portion. Lordship, this is missing, Lordship, from the paper. It's written in the index also. This part, Lordship can go to serial number 41, Lordship, index part. Index part. This statement is missing. That could not be provided, Lordship. Whether it is the court record or not, that's my friend with me. That 41 is missing. It is stated under 164 service. It is stated in the index part.
No, it cannot be because during investigation, I have recorded the statement of Rajan.
Yes.
It cannot be 164.
Cannot be 164.
It has to be police statement. It will not make much of a difference.
Okay. But here, Lordship, I am on the part that there is no chain of events from the prosecution side. Then I will come to my part. I'm only on that part, Lordship, that there is the prosecution could not give the chain of events after jumping out of the car. After jumping out of the car by Pankaj Devnath, who killed him? There were Lordship, who killed him? There is no forensic, no fingerprints were taken, nothing was taken. Then who killed him? On that Lordship, if nobody knows who killed him, there are other persons also. Lordship placed here, they have proceeded against Shahjahan Ali, Moinul Haq, Ibrahim Ali, Saidur Islam, everybody. Then Ibrahim Ali and Saidur Islam was being acquitted. Who killed him? That is not known to anybody.
কোনো covert role নাছিল। So they have to give an explanation to get away from that. Last in proximity. PM to exam. Strangulation and murder for Yes, then.
Lordship, I'm on the forensic ambiguity. There is during the cause of the death, but if there is nothing was that the forensic in the criminal eye, as per the prosecution's ability to conclusively establish the fact that the victim of intentionally killed by the accused. That cannot be. They cannot prove it. That chain is not there. Targeting only I killed him. The Moinul killed the Abhimanyu. That is not in the case of prosecution, chain of events, Lordship, as placed by the court. Because, Lordship, after jumping of the car from the vehicle by the Pankaj Devnath, there is nobody knows what happened. That part, and there are another 3 persons. There is, Lordship, after jumping of the car, there is Moinul Haq, Ibrahim Ali, Saidur Islam, and Saddam Hussein. There are other 5 person, lordship. 5 other persons. And who killed him? Who killed him? PW2 first said that somebody struck in the head. There is no injury as per PM report. Lordship. And here, who killed him after death? It was not the police did not give the forensic report. Police did not took the.
But what about the aspect that we'll also deal how the others were acquitted? That's a different matter. But all 4 of you were found to be with the deceased.
Right.
And the last sin theory
Yes.
would apply because the proximity also of the death from the moment when PW2 had seen
Right.
that he jumped
Yes,
out of the
yes,
vehicle.
I will go on. I will.
That aspect you have to touch.
Yes, I will go on that last sin theory also, lordship.
The deceased was with you.
Right.
In a vehicle. There were other passengers also.
As per the allegation,
Thereafter, the deceased
as per
had
the
died.
PW2 lord,
Yes.
as per the lordship, as of now, lordship, by the Nageswar Rao judgment, lordship, first lordship prosecution has to prove the scene of events, then the 106 burden of proof, my part lordship explanation will come. Then also lordship here.
No, leaving aside the aspect of injuries,
Lordship.
but PW2 says that he was in the vehicle along with the deceased.
Lordship.
And when he saw the deceased being hit by a bottle, he jumped out.
Yes.
That was the last he has seen the
Yes,
deceased along with the accused persons.
Lordship.
How do you overcome? How do
Yes,
you come
last
out?
in theory, yes, I will overcome that part I'm explaining, lordship. Last in theory, if there is last in theory, lordship, it will apply to everybody, lordship. It will apply to all the five occupants, lordship. It will not apply to only selectively who will be there. And here, after jumping off the car, the body was recovered after around 10-12 hours. After 10-12 hours, last in theory will not apply. There is a judgment, lordship. Last in theory will not apply because last in theory.
What about the recovery of the vehicle in that place? That
Yes.
witness that who had seen the vehicle being stuck in the mud and he had.
No. He has not stated the mud. He has not stated that. He said that who has done it, he will see it, but it was not asked. He has not stated against us. Mud.
No.
That spade was not lordship can go to. It was not that mud part lordship is not Mali lordship, I think.
PW11, page 29.
Yes, lordship. Lordship can go to last part 30. I would recognize the person who had borrowed the spade from me on that night if I see him. That means they were in the on that day they were in the dock. He don't know who he did not know who was there. And here, lordship, there is a if that was not recovered, that part.
No, that you cannot infer that they were in the dock yet not recognized. We do not know whether they were in the dock or not.
Yes,
on that day.
That's true, lordship. That part I am not controverted, lordship. Here, lordship is going to this recovery. Then there should have been disclosure statement. There should have been there is no that part is being recovery of the only the vehicle. How it will help if it is recovery, lordship. Recovery from the if the vehicle is being recovered. I am denying that this evidence is not saying that vehicle is being recovered on my instance. This will not prove evidence. Evidence, the lordship can go to the witness, lordship. And police in the and one more part, lordship. Police has stated Moinul has confessed. It is confession. Confession is not acceptable under evidence check. This is not. IO has not stated that they have disclosed. It cannot be considered as a disclosure statement. They have considered an evidence act is not applicable. In this case, that I will get the benefit 25 of evidence act. That is Moinul confessed it. And again, confession, his IO says that it is
No, we
confession.
are not giving any heed also. Whether he
Here,
confessed it or
lordship,
not,
last thing,
statements made before the police, those are not evidence.
it is not-
Unless it leads to some discovery of thing,
Again, lordship,
that will be
that
saved under
vehicle-
27, but we
police
are
say-
not on that.
where that 27 of evidence act that recovery of
Discovery.
of that thing, lordship, that is not applicable in my case, lordship, because what will happen, lordship, there is a
No, that has not been held to be applicable. Why are we going to 27?
no, that is not applicable. Here, lordship, last in theory, lordship has quoted me. Last in theory is not applicable in my case, lordship, because Pankaj did not jump out of the vehicle. There were 5 occupants. As per Pankaj Jamnar's statement is also inconsistent, Lordship. And what had happened after recovery of the dead body? Who recovered the dead body? When recovered the dead body? That was not being exhibited. That is not been exhibited by the prosecution side. And in that event, how can the last seen theory will be applicable, Lord? Here, my simple argument is that, Lordship, that as because inquest report was not been exhibited by the police, by the prosecution side, so that last seen theory also cannot be applicable in this case, Lord. When he died, it is not been stated in any way by the prosecution side. And prosecution, that 174 proceedings also is proceedings, Lord. That 174 proceedings is an important proceedings, Lordship, to determine mandatory procedural. It is a mandatory procedural document in as per 174 of CRPC. It purpose to establish the initial facts regarding the cause and circumstances of the death, noting visible injuries, position of the body, and other details relevant to the scene, Lord. In that 174 proceedings. And the inquest report does not determine the cause of death, but rather records observation that help assess whether death was accidental, suicidal, or homicidal. That part was never been exhibited, and how we are not being able to, we are not privy to that also. Legal, that the CRPC mandates that the preparation of an inquest report by the investigation in cases involving suspicious death. So, Lordship, whenever these things happen, in failing to prepare a report, the investigating authority neglected as procedural requirement, which could indicate an oversight or deliberate omission, Lord. Then, Lordship, in forensic report, noted ligation mark, but lack definite evidence of internal injuries, leaving the cause of death uncertain. Cause of death is an inquest report might have included observation about visible injury and other signs of the body that could corroborate or clarify the forensic findings. Without an inquest report, the prosecution lacked contemporaneous record of the body's condition at the scene. Lordship, my simple argument, Lordship, regarding lasting theory is not applicable. I could not, but to be some after the break, Lordship, I will give some, lasting theory will not be applicable because I don't know who knows, nobody knows when he died. And by the blow of the, by blow on the head, Lordship, there is an injury as per the PW2. Blood coming, he saw blood coming out of the head, and postmortem says no injury, is strangulation. Lordship, I am only, honestly speaking, Lordship, here I am not going to the evidence for Lordship. The defense side was being only on the chain of events.
Who is this CW1? Court witness?
DD entry, Lordship, Mayong, Lord.
How many court witness? One.
2. Lordship, but one major flaw, Lordship, that GT was never being exhibited. Lordship, can go to page number 1, Lordship, finally, Lord, page number 1. No, page number 1, Lord. The basis of this FIR is GT entry number 644. That was never been exhibited by the prosecution. there is no direct evidence of it. So prosecution has to prove all the evidence in a the theory of circumstantial evidence, Lord. So my simple submission before your lordship that the chain is not there. When there is a 174 proceeding is the mandatory proceeding of the that inquest report proceedings that was never been exhibited. We don't know. We are not privy to that also. Sir. And in that case, lordship, my simple submission, my humble prayer, lordship, that judgment may, if this become maybe I'm relying on this judgment, lordship, that these documents is a very necessary. FIR, medical documents here. Last part of the para number 33, the no medical documents, including inquest report and referral letter, have been exhibited. These three are not being exhibited in my case. In this case. But in para 35, there is a Supreme Court judgment also on that, my judgment, lordship, that Kalyan Brahman judgment. So that's a reference of Supreme Court judgment also. That in the court have to arrive the truth which is necessary for just and proper disposal of the court. Further, in the case of this is Rajendra Prasad versus narcotics.
Paragraph
35 plot. The Supreme Court has held that lacuna in the prosecution must be understood as an inherent weakness. Inherent weakness as a or a latent waste in a matrix of the prosecution case. The advantage of it should be normally go to the accused in trial of the case. But an oversight in the management of the prosecution cannot be treated irrevocable lacuna. In the present case, the prosecution have failed to produce witnesses and failing to exhibit documents. And failing to exhibit documents to enable the appellant accused to have all the opportunity available to him to prove his innocence. We are of the view that the advantage in the inherent weakness of the prosecution case should be to the advantage of the appellant. So for the ends of justice, it might have not been proper for this court to remand the case back to enable the state to collect the medical documents and make doctors prosecution witness. Besides exhibiting documents such as inquest reports, etc. Due to the fact that the incident had occurred in the year 2010. We are of the view that it would not be proper to remand the matter after such a long period of time. There is every possibility the doctors and the documents not been available any longer. In that view, the matter we are of the view it could be decided on the basis of materials on record. Then accordingly, not here in this case, accordingly, we have the reason we have the view that prosecution has not been able to prove the guilt of the appellant beyond all reasonable doubt. That thus appellant would have to be given the benefit of doubt in respect of charges under 302, 498.
Okay, we'll come back at 2 o'clock.
Doctor.
We'll come at 2 o'clock. Urgent matter, something else at 2. We not for listing filing of mention memo. Sorry.
Lordship was regarding lasting theory, Lordship.
Speak now. I will about us to postpone for listing mention. Why should we?
May I, Lordship?
Yes, please.
Okay, para number 15 and 17 is relevant, Lordship. The pardon on the accused would therefore kick in only when the last inquiry is
Just a minute. Para number 15
and para number 15 to 17.
Yes, please read.
The pardon on the accused would therefore kick in only when the last inquiry is established. In the instant case, at the cost of repetition, that itself is in doubt, it is born out of subsequent decision of the court, this court, which we would advert to. This is Kanhaiya Lal. The circumstances of lasting together does not by itself and necessarily lead to inference that it was the accused who committed the crime. There must be something more establishing, connecting between the accused and the crime. Mere non-explanation on the part of the appellant in or constituted by itself cannot lead to proof of guilt against the appellant. Then there is another judgment, SCC 2016-1 SCC 550 with relevant content. In the light of the above, it is seen that whether the facts of the circumstances of the case, the courts below were right in invoking the last intent. From the evidence discussed above, this is Manoj allegedly left the truck on that is number on 23/1/2021. The body of the disease Manoj was recovered on 26/1/2021. The prosecution has contended the accused person were last seen with the disease, but the accused have not offered any plausible cause and explanation as to what had happened to Manoj. Be it noted that only if the prosecution has succeeded in proving the fact by definite evidence that the disease was last seen alive in the company of the accused, a reasonable inference could be drawn against the accused that the only onus can be shifted on the accused under Section 106 of the Evidence Act. During the questioning under Section 103, accused having traveled the truck, as noticed earlier, the body of the Manoj was recovered only on 26/1/2001 after 3 days. The gap between the time when Manoj is alleged to have left the truck and the recovery of the body is not so small to draw an inference against the appellant. At this juncture, yet another aspect emerging from the evidence needs to be noted. From the statement, this is the main part is there, Lordship, para number 6B. Lordship, here, last in theory cannot be applied because prosecution has to prove the guilt, Lordship, first link. And again, Lordship, this another judgment, Lordship, this is stain is this is when the stain is not compressed, falsity of defense, no ground to convict the accused. 106 is another judgment, Lordship. It's not one, it's not, it's just that the burden is on the prosecution that there is a link, Lordship. Here, in the whole sequence, Lordship, the prosecution could not establish one point that who actually killed Abhimanyu. Because there were 5 occupants in the vehicle, 2 were being acquitted. After Pankaj, they have not. They have just.
Why are you citing Nagendra?
Nagendra, Mr. Not for it, not that prosecution has to prove first sequence. After that, ownership on that part. That 106 will apply only in that case, Lordship, when the prosecution is able to establish the chain of events in circumstantial evidence. Lordship. Lordship, one more thing, Lordship, regarding the statement of the IO, which is also inconsistent. Lordship, this Abdul, Lordship, regarding IO has stated that regarding arrest of that 2 accused recovered, which is 411, the vehicle was being done, he stated that he is also inconsistent. He said that Ruful Amin was arrested first, then Baharul Islam. But the PW number 4 has stated reversely, Lord. So this is also inconsistent. This IO statement is also inconsistent, Lordship, in one point. And regarding my only ground, Lordship, my ground is that prosecution failed that 174 is a mandatory provision. 174 proceedings under CRPC, Lordship. You can go to 174 of CRPC, Lordship. Police to inquire an importance, etc. Mary?
Just a minute. Yes.
Yes, Lordship. When the officer in charge of a police station or some other police officer specifically empowered by the state of government state government in that behalf received information that a person has committed suicide or has been killed by another, or by an animal, or by machinery, or by an accident, or has died under circumstances raising a reasonable suspicion that some other person has committed an offense, he shall immediately give intimation thereof to the nearest executive magistrate empowered to hold inquest. And unless otherwise directed by any rule provided by the prescribed by the state government, or by any general or special order of the district or subdivisional magistrate, shall proceed to the place where the body of such deceased person is, and there, in the presence of two or more respectable inhabitants, there should be two inhabitants of the neighborhood, shall make an investigation, draw up a report of the apparent cause of death, describing such wounds, fractures, bruises, and other marks of injury as may be found on the body, and stating in that manner or by what weapon or instrument, if any, such marks appear to have been inflicted. Then para 2, clause 2. The report shall be signed by such officer and other person, or so many of them as concurred herein, shall be hence forthwith forward to the district magistrate or the subdivisional magistrate. When the case involves suicide by a woman within 7 years of our marriage, or in the case related to death of a woman within 7 years of marriage, in case related to death of a woman within 7 years of marriage, then there is doubt regarding the cause of death. When there is doubt, any doubt regarding the cause of the death, or the police officer for any other reason consider it expedient to do, he shall, subject to such rules as the state government may prescribe in his behalf, forward the body with a view to its being examined to the nearest civil surgeon or other qualified medical man appointed in his behalf by the state government. If the state of the weather and the distance admit of its being so forwarded without risk of such putrefaction on the road as would render such examination useless. The following magistrates are empowered to hold inquest, namely any district magistrate or subdivisional magistrate or any other executive magistrate specifically empowered in this behalf by the state government or the district magistrate. That is 175 power to summon during this is a proceedings lot before a murder case is being examined. One power to summon person, a police officer proceeding under 175 may or by order in writing summon two or more person and approach for the purpose of the state investigation, and any other person who appears to be acquainted with the facts of the case, and every person so summoned shall be bound to attend and to answer truly all questions other than questions the answers to which there would have been tendency to expose him to a criminal charge or a penalty or forfeiture. If the facts do not disclose a cognizable offense to which the section 170 applies, such person shall not be required by police officer to attend a magistrate court. Inquiry, this is by the cause of the death. Inquiry by magistrate into cause of the death. So we are not going to tell the proceedings under 174 of CRP was not being followed. This is a mandatory provision, and the prosecution missed the circumstances leading to the discovery of the body also. And earlier also I submitted lordship, the main ground lordship after coming out of the vehicle, PW2, who is inconsistent in his statement also. That what happened? Who killed? There are 5 occupants. There is no fingerprints were taken, no forensic, no DNA, nothing is being taken by the. It will be one type of perfunctory. One major thing, the perfunctory investigation also can be called lordship, because nothing is being, no forensic science, nothing evidentiary value evidence is being collected by the police. So now lordship, nothing is being implicated that Moinul killed her. Beyond reasonable doubt, it is not, prosecution could not establish the fact that Moinul killed the victim. How you mean? Moinul killed the victim, it is not being established. And again, Lord, if we consider the person of the PW2 stated that prior to jumping of the vehicle, Saddam hit in the head. And here, Lordship, there is it is presumed that he died, he becomes senseless after hitting in the head. That means prior to his death. If we consider the PW2, but PWD is not being supported by post-mortem report because post-mortem report says that it is strangulation. So there is a Lordship, the sequence. I'm only on the sequence, Lord. The prosecution could not establish the sequence, Lord. Chain of events. And mainly, Lordship, there are 5 occupants who were being acquitted by the trial. And nobody knows who killed him because no fingerprints, nothing has been examined, nothing has been exhibited.
There was no charge under 34.
No, Lordship. Again, 149 is also not there.
That is conspiracy. That's a different matter. 34 is different.
Assembly 149 is also not.
149 has to be preceded by 141. 149 straight away not first. There has to be an illegal assembly.
Unlawful assembly.
Unlawful assembly under 141.
Yes. That is also not there, Lord. I will reply, Lord.
Just a minute, just a minute. Who have been acquitted?
His Lordship, Ibrahim Ali and Saidur Rahman.
And rest 3?
Rest 3, Lordship, one is a juvenile. Not acquitted.
No. It's a total 5 persons.
Lordship.
Ibrahim and Saidul are acquitted.
Acquitted.
Mainul is there. 3.
Mainul is there.
3. And who? The rest 2 are there. Who are they?
No, this was the 411. This 411, not the occupants of the vehicle. No, the 411. They were 411. No, but they put people.
Okay. And this
Ruful.
PW2
PWD,
because number 2.
here Lordship, PW2 said, Saddam informed the police about the accused person. Police told me the name of other 2 persons that are included in the affair. PW2 states in the page number 15, last paragraph, Lordship, that he does not know the name of myself, Lord. He knows only the name of Saddam, who struck in the head, Lord.
What about the other offense so far as the attempt to strangulate the informant was concerned?
Yes, Lord, that I will come, Lord. That I will
Is
come.
there any conviction under that for that?
No, regarding that part, Lordship,
No. Is there any conviction of Mainul?
P23 also finds.
yes, Lordship.
No, one of what?
Here, Lord, here, Lordship, exactly similar evidence comes against me, Lord, here in Pankaj Devnath also. The parity part will come here in this case also, Lord. Here, Pankaj Devnath part also, because Ibrahim Ali and Saidul Islam, PW2 has indicted, or it says that all the accused person attacked him. All the accused person, Lord, we can go to the PW2, Lord. Evidence part of it. Page number 13, Lord. Page number 13.
1-3.
1-3, Lord. Lordship, I'm reading in the middle part, Lordship, which is relevant, Lordship. May I, Lordship? Then I have seen Saddam holding a bottle in his hand, and blood was coming out of the backside of the head of Abhimanyu. Then I opened the door and jumped out of the car in panic. Then all the person came and hold me tight. One person grabbed my chest, and all the person came and hold me tight. Lord. Here he has indicated all the person, but the trial court convicted only me, Lord. Here all the person hold me tight. One person grabbed my chest, and one of them got seated on my chest. One of them started strangulating on my neck. Who strangulated one of them? Lord. One of them shouted that my neck should be cut off. Then they thought that I died that time. They kicked me aside and left that place. After that, I was lying on the ground for 2.5 hours. Here, Lordship, contradiction part was not being cited, but one Lordship will be relevant. Lordship, page number 168 also. Page number 168.
Just a minute, please.
Second, I 164. Page number 168. But PWT is married. Married, Lordship.
Yes.
My name and address as mentioned above. I am 20 years old. Around 3:30 p.m. on so and so that I went with my friend Abhimanyu business to Akasinganga, Nagaon. In his also 800 vehicle, taking along with 3 persons, Shahjahan Ali, Moinul Ali, and Saddam Hussein. We were at Akasinganga for half an hour, 1.5 hours. After that, we returned from there and arrived at Jagirat at 9:30 p.m. Then Moinul asked Abhimanyu to drop them at Poha. As it was already night and they would not get any other vehicle to go, therefore Abhimanyu got ready to go to Poha and we proceeded towards Poha. On the way, Moinul asked to stop the vehicle at the Kodamtoli and took 2 more persons with them. Abhimanyu opposed, but Moinul said they were stop. After that, we again started our journey and then we reached Nabha Bhatia. Saddam dealt a blow on the head of the Abhimanyu. This is consistent, his statement, with a glass bottle. On seeing that, I got frightened and jumped from the moving vehicle by opening its door. Immediately, Saddam and 2 other persons who boarded the vehicle at Kodamtoli, that means he indicated the person who got acquitted, Lord. Immediately, Saddam and 2 other persons who boarded the vehicle at Kodamtoli came running towards me. One of the person who boarded the vehicle at Kodamtoli sat on my chest, while the other strangulated me. and Saddam asked them to cut my neck. It was very specific, Lordship, who did what the role of the 3 persons were there, Lordship. Then I pretended to be dead, thinking that I had died due to strangulation. They dragged me near the road and leaving me there. They left the spot. After that, they had left. I went to a residence located nearby, took a mobile phone from them, and made a call to my house. About half an hour after, 3 persons, so and so, came, and half an hour after that, people of the house arrived here. Then police came. We all made a search for Abhimanyu at night itself. Lordship, here, the crux of this is, Lordship, the PW2 is always inconsistent, Lord. Inconsistent. In the PW2, before the court, Lordship, he says that all the accused person he tried to strangulate him and kicked him. But in 164, he indicated Saddam and the person who got acquitted. He tried to strangulate him. And the person who got acquitted, in fact, strangulated him, tried to kill him, and Saddam asked to directed to cut his throat, Lord. So, Lordship, here Mainul is nowhere indicated, Lordship. In the prosecution could not able to prove that chain that Mainul is involved in this case, Lordship. In the hitting of this Pankaj Devnath also. Likewise, Lordship, while I was submitting, Lordship, in the 302 part also, the part is that the culmination of crime, burden of proof, beyond reasonable doubt, prosecution is not being able to prove that Mainul has did all the things, that killing and strangulation also. And here, Lordship, that parity part, exactly similar evidence, parity part covers in this case also. This Pankaj Devnath also, which will apply, Lord. Right.
Madam? Yes.
First circumstance that 3 persons had boardedly hired the vehicle. These are undisputed facts. 3 persons. Who are these 3 persons? Saddam Hussein, the appellate, and Shahjahan. Saddam Hussein is a juvenile. He was sent to juvenile court by the police itself before the event, before the investigation. And Saddam Hussein is absent.
No, Saddam is a juvenile.
No, Dimapur.
Saddam?
Saddam is
juvenile.
juvenile.
And Shahjahan is absent.
And third, 3 persons you have said.
Mainul, appellate, Saddam juvenile,
And
Shahjahan.
yes.
These 2 persons comes later. Yeah. So these 2 persons had the vehicle and had taken the deceased as well as PW2 to Nova. They went to drop it to Nova. And then while they were proceeding towards Nova, Abhimanyu, the deceased, asked the 3 persons sitting in the rear seat that where to go. And these persons said they forgot the exact place. They said to proceed. Thereafter, they went forward. They waited in a particular place at Akaki Nokka. There they stopped the car, and 2 of the persons went up. No particular place. Then they waited. After some time, 1 person came out and said that they would take some time and requested them to wait. They waited. They had some tea and all. And after that, 2 persons came out. They said that the work is done. And then they returned. And these 2 persons, I think Saddam was inside the car, And these two persons went. And then they came back. Matter was over. They came back. They reached Jagi Road. They reached Jagi Road. Thereafter, Moinul said,
The vehicle was hired from where?
from their place, Baboka. No, it is from the place of Abhimanyu. They
What is
went
the
from-
place?
Yes. So they went from
What is
Jagi
this
Road.
place? Abhimanyu's place.
They went from Jagi Road and it's from Bhakti.
The vehicle was hired from which place?
Jagi Road
Jagi Road.
was not Baboka.
This is used to stay at Jagi Road.
It's his place in Jagi Road. And his place is some Gunducha Bhakti.
That is okay. From but more or less Jagi Road
Right.
location. They took the vehicle. This is vehicle who along with him took PW2 also. Three of them had the vehicle saying that they would go to Nagaon. On the going to Nagaon, they stopped in somewhere in between. Then two of them had gone out to a house. After they are finishing the work, they came back to the vehicle. Then the vehicle came back.
They back to Jagi.
Okay, then
Then at Jagi Road, that Moinul said that they have to go again to Boha. Then it was quite midnight and then Abhimanyu was reluctant. But then they said that they don't give any other vehicle, so they requested and they Abhimanyu went towards Boha.
Boha is which side?
Boha is again Nagaon side. See. So again that's it. So they went to Boha. But this is a story, this is a fact which is stated before the class. Now the 164 state,
It is not Roha, no?
not Boha, Boha, or Boha.
There's a call.
It is a sports of Boha.
জানেন এই Boha বলে জায়গা?
In 164 statement, what you can see, in his trial statement, he said all the three requested him to go to Boha. But in 168, 164, he said only minor said take him to Boha. Because why I'm stressing on this? 120, I have to bring that.
Conspiracy.
Along with evidence, because 109 will also come with 120. So in 168, he said Moinul asked Abhimanyu to drop them at Boha. It was already night, they would not get any other vehicle, so they went towards Boha. Thereafter, and while during the first trip, when the two persons went to a particular house, then Saddam was sitting in the vehicle. Saddam did not go. It was Moinul and Shahjahan went inside the house. Saddam was So Saddam was inside the car, they came back to Jagiroad. Why I'm stressing on Saddam is that by that time they had an introduction. And here, PW2 knew Saddam by his name. Because Moinul was not known to him. So Saddam dedicated not known. So Saddam, when was inside the car, they had the dog, thereafter they finished the work, they came back, thereafter they again went to Boha. And then 164 statement, Moinul asked government go to Boha. Then while they were going towards Boha, they met person, they saw two persons waiting at that midnight hours. They saw two persons waiting, then Moinul said, take them inside. This is what 164 PW2 said. 164 can be used for corroboration as well as confirmation. So Moinul said, in this 164 statement, that On the way, Moinul asked to stop the vehicle at Kadam and took more persons with him. So Saidul and the other person.
Ibrahim.
Right. So according to PW2, in his 164 statement, he said, Moinul asked him to bring the person inside the vehicle. So they were brought. They set. And after that, this is first circumstance that I said that all three persons, these three persons hired the vehicle, and on the way, the next trip, they took those two persons also. Parity will not come. Because parity facts has to be same. Here the intention was from the beginning, 120. Now, criminal act, 2 of illegal act. Now, after that, second circumstance that Moinul took 2 persons inside. Then after going to some distance, third circumstance, after going to some distance, PW2 heard a sound. Of course, he did not see. He said in his statement, I had not seen exactly the blow. He heard the sound of a glass breaking. And then he saw the hit on the head. Said it is a hit on the head. And then he got down from the vehicle.
No, in 164 he says,
Ah.
he states that he saw Saddam dealing with a blow.
But then in his cross-examination, he did not say. In his cross-examination, you can see at page number 14. There he said, yes, and for page number 14, you can see first paragraph, 3 lines from the bottom. In his cross-examination, first paragraph, 3 lines from the bottom. Page number 14. He said, after I heard the sound, Lordship got 5 sentences from the bottom.
Yes, yes.
After I heard the sound, the head of Abhimanyu was slipped towards right. I have seen the bottle in the hands of Saddam. I have not noticed if Saddam hit the bottle on the head of the deceased. So this negates his exact scene of the event. No blood was spilled on my body. I jumped out of the car. But then he was sitting next to, of course, another person who boarded the vehicle. He wasn't between, but he was sitting next to the second person, the same guy. He was in the transit. So he can make out when he has not seen the exact blue. So he heard the sound of a bottle where he saw that his head was leaning right, and then he jumped up of the vehicle. And then Lordship notes, after he jumped out, these people chased. Maybe Moinul was not there. 164, he does not talk of Moinul. He chased and they injured. Then he regained his consciousness. He went to the house of PW1, made a
Yes.
But there is a contradiction. Lordship will see that contradiction does not stand. Contradiction, Lordship will see at page 15. Page 15, first line, by PW2. I have not mentioned anyone's name in the statement recorded by police. It is not the fact that I have not stated before the police that when we reach Akaki Ganga, Abhimanyu, Saddam, and myself remained sitting in the car, and other 2 got down. It is not the fact that I have not stated before the police that I heard the sound of bottle. When I turned it on, I have seen blood coming out from the head of Abhimanyu, and Saddam was holding a bottle. It is not the fact that one of the accused tried that my neck should be cut. As if there is a contradiction, but these statements were not placed before the police. So contradiction is not true. So we will not go into that. So we can stick to the statements he gave in his examination in jail. not demolished by exam process. So these statements stands true. There is no contradiction. As far as this knowing minor, Lordship will see at page number 14 only. When Saddam was sitting in the vehicle and the other two had got down, he had interaction with Saddam. They had a formal interaction. So he knew Saddam. Not before the incident took place, but inside the vehicle, he came to know about Saddam. Moinul and other persons he was not. Lordship will then come to the court question at page number 15. Court question, Lordship will get in the bottom part. You have told that the name of the accused persons inserted in the FIR were told by the police. Where from police got to get those names? Then he answered, at the time when I went to the police station, I have seen Saddam there. He knew Saddam. I identified him as the person who injured RWMD. The police interrogated him, and after that, police told me the name of the accused. So he came to know about Moinul and other sergeants. So this is the explanation he gave about the identity of the accused person. And the cross-examination also he reiterates 3 lines from the bottom. Saddam informed police about the accused persons, and police told me the name of the other 2 persons that are included in the FIR. So this is how he came to know about Moinul and Saddam.
Saddam informed police about the accused person and police told me the name.
Thereafter, Lordship. Now, of course, what he said, Saddam has written in medical evidence says
No.
nil.
Hmm.
I checked the inquest report. Inquest report is there in the file, not written in proper, but I can make out as an inquest report and mark the Lordship and see what's, because it is not essential. But Lordship can see that. Here, they say about injuries on the neck and the ear. The inquest. In the PM report, it said no injuries at all, only the internal. But in the inquest report, there are injuries on neck and ear. And other
It
witnesses.
is very unfortunate that the PM has been done in such a perfunctory manner. Very mechanical, very mechanical manner.
Original documents not there.
That's a different aspect. Have you seen the manner by which the PM has been written? As if it had to be completed in 1 minute.
All nil.
Oh.
Inquest report, there is one line, injury on the ear and neck.
Even there would have been no injuries. When a person is strangulated, there would be other marks which would show his resistance. There was nothing. Nothing has been.
But then there are other evidence of these are lapses on the part. So not
So how do you connect this Moinul with the strangulation?
no, we cannot connect bundle with strangulation only by checking because 120. Because nobody had said there's nothing to get express strangulation.
120B it's a special kind of a thing. You cannot just bring in, rope in.
I'll come to that one small hyper judgment where it said 120B, 302.
And what about the other 2 persons? They have been acquitted.
Other 2 persons.
They were very much there. If you say, and it also appears that these 2 persons who were picked after going again from Jaggi Road were at the instance of the appellant, because he said that they are staff of my shop. That is the particular statement we have recorded somewhere. Moinul said, I know them. They are staff of my shop. So it was Moinul who insisted that these 2 persons should also come in. And those 2 persons have been acquitted.
Because first thing that names were not given in the FIR.
No, that is not an excuse. Names may not be there at all, in an FIR at all. Nobody may be named.
Unknown person.
Unknown
said.
person.
But whatever facts are little different. They were there from the very first instance. They came in between. Cannot say parents. Facts are. And then they left. They left. Because that sentence cannot be relied on. But police said, Moinut said that when he tried to strangulate PW2 by chasing him, they left. These two persons left. So only these three are there. So taking, we cannot rely, but taking precautions, they were not there. When Abhimanyu was strangled. Then what I want to express on is
Just a minute.
injury
Just
part.
a minute. Excellent. 120 B look yes. Or wait a minute. Resume करो. 160 गाड़ी चा वैसे PW2 गाड़ी चा ढाई से जो नहीं से Jumped in all the buttons. এখানে কিন্তু যে চলছে না কারো নাম কোয়া নাই সাধারণত অকল বটলৰ পিছত এইখিনি কোৱা নাই কিন্তু তাক কোনে খেদিলে গোটেইকেইটা হাবলৈ গৈছে কিন্তু জগত
morning, the first and then found dead body where dead body dead body this the body was about body was about dead body. The dog had so that time said no, but the night that secret information said that was going to start after my baby put a bath from it. The vehicle was about Poha. Bahar to but wait like how Bahar don't have to Bahar. That is about to find the page number 30. Initially rule. Rule if recover ultimate mobile phone from school. Then on stating by rule that he has given calculated Bahar of the same thing went to Bahar and got so 400. Five point five and then about the vehicles Bahar here he says for all sides. For Bahar, after that, the fourth round. And period 5 has said that Gamuda was also was going to brought going to that Bahar. Period 5. And then the law. The fact after on that time and the only of the body was body was covered. Not that long after. That was months ago. Then he's fired there, came back, and then and as per medical unless big doctor said was a fire, doctor was fired, and medical evidence was of fire. Then that medical evidence of fire. But otherwise, mother and brother-in-law, they cannot wife of, they cannot they were so so medical process going. So in this fact, I not popular evidence if there is not a big diet of friends, there was another person and his so as far as the that fact that doctor mother of the deceased is 7 age 20, age 20. Last time I saw many started from the body. That was not from both mother, then wife of the deceased there was, and then why not? You know, so these are like way higher. Expired.
No,
Thora,
no, not retired. No, CPI, is by CPI. The register was seized by CPI. 31.
and then one all that we are Moinul was there of good, not down. And if the doctor was and Moinul go like stop. Other vehicles belonging to Jakir Road, Lahori Ghat, from one of the vehicles, one Moinul was brought down. Please ask Moinul about house of Bull. Moinul led out. Where police arrested Bull? Where from police went to Baharul and arrested Baharul? Baharul and Bull taken by Jakir Road and the mobile phone of the was recovered from Dukdu. But he said at that time Dalil was also with the five, right? At that time Abdul Dalil was also down. Said that why the Dalil got out. So connected up. But this mobile Abhiman mobile got back card. One one I took care of following one uh, 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 one I got card. And then I recovered the that report. I recovered the mobile and the driver of my from Pula. I think that mobile four. Mobile and the pocket
Take this one too. Take this one. Itu post to any part. We have signed in a blank paper.
one
PW started 4 and 5. PW 6 started 4 and it's tough. But but
That's what but once they did driver, once they are but why of occupant of I don't I got people I went to public after on that at my passport. I saw that a court now the that picture wife and other my another 4-1. I did not find any person. I did not mobile phone cover. However, exit for another exit for from Lukula mobile phone of and the mobile phone of that Devnath also mobile phone of that I have said as I do never following mobile from possession of thing to cover from for this talk of another from 315 so for the vehicle was covered 45 mobile mobile phone that for another that for the so the house of who
Lordship, here.
After that, what happened? We think that what was thrown, the body was not. Then what? Thereafter, on then the body was taken, and then the down of the audio. Then audio said of those are but mainly yes, out of from those by some argument was recovered. Thereafter, Bahar thereafter. There. Somebody else was going to and it does one that 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 big how the big S9 paragraph 7. Ganga Bhavani Ganga Bhavani Ganga Bhavani Raya paragraph 7. It gives the existence of and says that past of paragraph then what with not this is this that but this is what is an effect that 2011 2 double Braham Swarup versus Jacob. You Jacob. Paragraph 7. And one of our context paragraph 7. Then one of our high court judge by of course 2020 2023 within bracket. So Sarva Patwa. Sarva Patwa. Patwa. Then the last one, the Allahabad 30, and the white eight of one, each Allahabad 2009, 2009, Allahabad one, six, seven, and five. No, no, Neeraj for and Neeraj UP. After that, one thing they have put it as one from what else in view of the above provision of law, even for an offense of criminal one punished as provided 109, and the person is involved in the criminal conduct of the offense, and he will continue the offense as provided for the offense, for the commission of which conspiracy. Therefore, hence the learned session judge committed very clearly about management of period of 5 years. What the learned session like one because he is an epic. But it would have these are not fair.
I reply, Lordship. Short reply, Lordship. I will not take that much time. Lordship, kindly go to two things, Lordship, regarding this judgment, Lordship. I don't have not gone well, or Lordship going to the ocular evidence. My learned friend has said this is not a ocular evidence case, Lordship. This is nobody is ocular here, Lord. This is not the sole witness. He is not the sole witness. So this judgment is not relying. And the second part, only sole witness. He is not the sole witness. That judgment is covered only, I think, sole witness. Anything. Lordship. And regarding next part, Lordship, that discrepancies in the that's called inquest report that I am just referring to by my plans that when the inquest report was being produced, Lordship. Here in this case, Lordship, inquest report was not never produced. We are not privy to it. We have not cross-examined it, and that part is even fully dealt with the judgment I have given, Lordship. And regarding one point, Lordship, kindly go to that recovery part, Lordship. Kindly go to page number 18, Lordship. Just small time, I will take not much time, Lordship. 18, page number 18. Here, Lordship, it is a statement of Abdul Jalil, who is the one of the Caesar witness. He said, I'm giving only the relevant part that who I Sarkari Gambura person. At that time, I was serving as a same. On a particular night at 3 a.m., police personnel came to my house, took me to the police vehicle, and asked me about the house of the accused Baharul. Then I led them to the house of the Baharul. Police arrested Baharul. Here, Lordship, that I am just saying that here Abdul Jalil said Baharul was arrested first, then Ruful was arrested first. And then, Lordship, what had happened? PW5 says that I am going to PW5, Lord. Moinul led police to the house of Ruhul. Police arrested Ruhul, and he said Ruhul arrested first, Lord. Then again, Lordship, I will go to Lordship, IO statement 13, Lordship. Here, page number 34. I, along with the on knowing this from Moinul, on the night of midnight hours, I, along with the PS personnel, went to the Kosari Bana with Moinul and searched the house of Ruful Amin and apprehended Ruful Amin. Whom to believe, Lordship? Here, there is a inconsistency on who was arrested first. PW4 testified that the police first arrested and apprehended Baharul Islam and then went to the arrest of Ruful Amin. In contrast, Lordship, PW5 and investigator indicated that Ruful was arrested first, followed by Baharul. This inconsistency, Lordship, in order of arrest, I feel Lordship, it creates confusion on the regarding the sequence of events during the recovery of process law. This also different. Again, Lordship, different description where the evidence was found, Lordship. PW13, the investigator testified the mobile phone of the deceased was recovered directly from Ruful Amin. PW13 says that the phone was directly recovered from Ruful Amin A4. Ruful Amin, this is equation 4. While PW4 and 5 claimed that the mobile phone was found in the car. PW6 did not confirm seeing the mobile phone at all, adding further ambiguity in the location of the and the source of the mobile phone's recovery. That part also goes. And regarding location also, vehicle location also, that part I am sequencing. The recovery of vehicle was critical on the part of evidence against Moinul and the accused. However, PW4, 5, and 6 provided inconsistency regarding where the vehicle was located. He has not stated where the vehicle was located and how the discovery process unfolded. PW4 and 5 mentioned in Mahamora LP School as the site of the recovery, but there were discrepancy in the specific details, each which is recalled. There is discrepancy lot. Where a chain of custody handling PW6 gave a limited that Lordship has appreciated, Lordship. Lordship, one more thing, Lordship, reserve witness PW4 signing of blank papers, they have signed in a blank papers. PW4 admitted they were signed in a PW4 and 5 and says that they were signed in a blank paper. 4 and 5 has stated. Here. That is page number 19, Lord. Page number 19. I put the exhibits as a serial list was a blank paper. Regarding one more thing, Lord. This put okay, any lot for the sake of giving Lordship, I'm just giving one transparent Lordship. Here, that is para number 27, Lordship. Recovery of materials, Lord, which is important discovery material object. The disclosure, therefore, burden lies on disclosure of the accused, but such disclosure alone would not. This is not disclosure. Then also automatically lead to the conclusion that the offense was committed by the. In fact, thereafter, burden lies on the prosecution to establish a close link between the discovery of material objects and its use in commission of the offense. This is not so. So, Lordship, there is nothing to recovery that the commission of offense was done by the Moinul Lord. Here, the prosecution clearly fails to establish the chain of events leading to prove that to prove beyond reasonable doubt that Moinul killed him. And again, Lordship, when there is a 5 inhabitants, 5 occupants, and there are two were acquitted, Lord. So 2 were acquitted. And again, Lordship, one major part, Lordship, while passing the order by the trial court, finally, Lordship, two opinions have been gathered by the trial court. 145, page number 145, Lordship. Lordship, is page number 145. And page number 155 of the paper booklet. Here, Lordship, trial court has opined while passing the order, I have already held that Abhimanyu Biswas has died a homicidal death due to strangulation. And Lordship, kindly go to the page number 155. I am reading, Lordship. Page number 150, I'm reading the relevant part. Here, does the bruise and abrasion injuries found on the neck and chest were apparently caused by the accused person physically assaulting Progna? Strangulation of neck is certainly with the intention to cause death while punishing the minor in 307 lot. The trial court opined. Attempt to cause death is apparently presumable, considering the fact that driver has already been hit on the head to cause his death. Here, Lord, the trial court has opined two opinions. In page number 145, he has says that he died due to strangulation, and in page number 155, he has opined that he died due to head injury. Fully, Lord, he has opined two opinions. Here, Lordship, I find, Lordship, as per my humble submission, so my burden regarding that contradiction part, I'm not going to, because the chain is not being completed. That Nageshwar Rao's husband is also there. Chain is not at all completed. After jumping of the jumping of the vehicle by the witnesses, Lord. And witnesses statement is also improving. It is improvised, Lord. It is inconsistent, Lord. And he is consistent only one part, Lordship, that Saddam hit on the blow. That part is consistent. Other part is inconsistent, Lord. My humble submission is that, Lordship, considering the materials on record, I may be nobody knows who killed whom, who killed the victim out of the five, and where fingerprints were not also taken by the police, and nothing was done by that part. And on two counts, Lordship, on the date of the Abhimanyu, I'm prosecution failed to prove, and again the attack on the informant. Lordship. Attempt the murder. No, Lord. While analyzing that 307, the learned trial has says the attempt to cause the apparently presumably considering that the driver has already. Yes. No, Lord, that's true, Lordship. I agree, Lordship. No, here, Lordship, here it is an attempt to cause that is apparently presumably considering that driver has already been hit on his head to cause his death. Here, it has been opined that driver was died due to head injury, Lord. Lordship, kindly go to the sentence, Lordship. Attempt to cause death is apparently presumably Lordship. Yes, Lordship. Yes, Lordship. Yes, 307. 154.
No, no. Statement of that.
Yes, Lordship.
Page 6.
Yes, that. So, Lordship, my submission is that there is two inference was taken while passing the order.
Here, first 365, they talk of informant only.
No, that,
Attempt to cause death is presumable
Hmm.
because even the driver was hit, so he was also
no,
he was also hit.
no, he
So at-
had to cause his death.
No, attempt-
Driver was the Abhimanyu. Here, driver
Since
has,
they tried to kill the driver, they
yes,
also
no,
tried to. that is
driver
not
has
it.
already been hit on his head to cause his death. Here, cause his death is there. So, cause his death is there. My understanding is maybe wrong lot. Say 5 lot.
55.
155 lot. Maybe I'm wrong lot. But my understanding is that lot.
Attempt to cause is
Attempt to cause that is
apparently presumable.
attempt. No. Middle lot.
155 middle
155
part after
middle part
10 lines. Or
after 10 lines.
attempt to cause.
Attempt to cause that. Attempt to cause that is apparently presumable. Consider which one? Pankaj Devnar, yes. Yes, does the bruise and aberration Pankaj Devnar. Strangulation of neck is certainly with the intention to cause death. Attempt to cause death is apparently presumable. Considering the fact that driver has already been hit. Driver is the, that is Abhimanyu. Driver has already been hit on his head to cause his death.
No, for Pankaj.
But while discussing for Pankaj, he has opined that driver was hit on the head.
No, this is what is
That is my understanding, my lord. That is, driver has already been hit on his head to cause his death.
since they tried to kill that, not for him. Fact.
This attempt is not a part. Here, why? Pankaj.
Hit. So he will also.
No.
be hit.
Driver has already been hit on his death. Here, Lordship 145, he has opined that he died due to strangulation in 145 page number. Then also, Lordship, I insist on Lordship only one thing, that prosecution failed to process the thing. Which one? If the such, there could have been a case of another homicidal death due to amounting one. Yes, if they could have, if they could.
There does a clear case.
Does a clear case of 307 causing simple hurt by blunt object along with attempt to commit murder of the Pankaj Devnar. Here, Lordship, here this part is not being so. Pankaj Devnar has in the 168, 164 has stated that no, Mainul has not hit it. 1307 is not applicable, Lordship, in this case. Lordship, here my humble submission before your Lordship that prosecution failed to prove one thing, Lordship, regarding commission of that death of Abhimanyu, the victim who killed Abhimanyu. It is not being established. That out of the 5 who killed Mainul, that part is okay. Regarding Abhimanyu part, Lordship, Pankaj Devnar part, Lordship, regarding attempt to kill him, Lordship. Here, one thing is clear that okay. In the yes, Lordship. Yes, Lordship. But here, Lordship, here if
164 is.
but here two are out of all of them tried to kill him in 307. But out of them 2 were being acquitted. 2 are being acquitted. Lord. So that parity, law parity will apply to me, Lord, in that case. Lordship here, Saddam Mainul Shahjahan was along with Ibrahim Ali and Saidul Islam were there. Ibrahim Ali and Saidul Islam were acquitted, Lordship. And again, Lordship, one Lordship. Huh? Yep. 14 March 2022, Lord. 14, 2020. Yes.
Operations, operations on operation on back and chest and
Simple.
neck,
And
back, chest and neck. Yes. Just to, just to nine. Trial court considered that at page 129. injury on Pankaj Dev. But trial statement will stand. It will corroborate as far as the other three are concerned, but Mainul will not go out because he said in his case it is only for corroborate. Yes, when Mainul was inside the car or wherever, but three only had attacked him. One sat on the chest. That- Hmm. Corroborating part of as far as injury to Pankaj. But this has not been put to it. Corroboration comes as far as these three are concerned. So Moinul will again be, I'll see some justice.
Because he is inconsistent also. His statement lot, he is inconsistent. All the way, even Rajan Deka also become the hostile.